No one in this courtroom had to endure what we had to endure.
Go sit down.
You may remember this heated exchange during the Parkland school shooter sentencing trial. Now, the Broward Public Defender's Office is calling for Judge Elizabeth Scheer to not oversee any more of its criminal cases. Weeks is also reflecting back on the sentencing trial and the threats his office has received since then. Here's our conversation. Mr. Weeks, thank you so much for joining us here on Impact.
It's my pleasure.
Many of us were closely watching the Parkland shooter trial. In this particular instance, it wasn't a question of if he was guilty or innocent, but this was only about sentencing. You represent the defenders in this trial. How difficult was it for you throughout this whole trial?
You know, it's an important function that we serve in the criminal justice process. You know, public defenders are an essential part to make sure that our Constitution functions and that we have justice that is handed out evenly and fairly. But you know, one of the things that can be difficult is that our clients don't choose us. They're appointed by the courts, and that means that sometimes we may represent folks that are somewhat unsavory. They may not have the best of circumstances, but we still have a very important role, and that's to make sure that we give and provide the highest level of legal representation to everyone that is before those courts. And that function alone ensures that our court system is going to be fair, it's going to be open, it's going to be transparent, but more importantly, that the justice will be respected in this community because we make sure that everyone receives the highest level of care.
When you have a case like this, that it's in this community, we are extremely hypersensitive to what happened here on that fateful day. All eyes are on this trial, not only locally and not only in the state, but throughout the country, and all eyes are on this trial. You are working under a pressure cooker. Your defenders are working under extreme conditions. What do you tell them on a day-to-day basis? You
know, I have some of the most talented, gifted, dedicated attorneys that work in this office. They have made a decision and they've pledged an oath to uphold the Constitution and do this work. I tell them to make sure that they do the work at a high level. But I'm ensured every single day because I see the level of commitment that they've given this case and every other case that they're assigned. The days that they've labored over the evidence, the difficult days that they've had absorbing and dealing with the trauma that's associated with having to pore over countless hours of videos that no one should ever have to see. Volumes and gigabytes worth of data that has to be reviewed. Upwards of 1 million pages of discovery that had to be digested and dissected and reviewed. And they do that knowing that there is a part of their personal life that will be sacrificed, their professional life that will be sacrificed, but they do it knowing that it's an important role. And if we fall short on the most difficult cases, then the community will not have confidence in all cases. That is our oath, that is our duty. And knowing that the eyes of the nation, the eyes of our community are watching, it is important to make sure that we represent the Constitution, represent the duty that we have to elevate the practice of law and to make sure that it is evident from the work that we care. It is difficult work, but even when confronted with difficult work, you have to persevere. You have to push through it because we know that this case is like no other, but it was the case that we had.
You talk about some of the personal sacrifices from the team, and they received threats, and they continue to receive threats. How do you deal with that?
You know, it's unfortunate that, there were mistakes that were made in this trial. It was very unfortunate to have the courtroom turned into a bully pulpit that was calling for violence to be directed at the attorneys that were doing the work. It was unfortunate to allow that space, that solemn space of court, of justice, of law, to be turned into a platform that was sending out dog whistles to folks to act negatively towards the attorneys. We made mistakes. The court made mistakes. I made mistakes. You know, when I spoke in court as an attorney, I need to be precise with my language. And although my intent was that the attorneys, no attorney had to endure what the attorneys endured, that was not communicated effectively. And for that, I am deeply sorry for the pain that caused families that interpreted it differently. I'm deeply sorry for the fact that, you know, the incident occurred with the finger in court.
That gesture I was going to ask you about.
That was an incredible distraction. But the mischaracterization of that, to suggest that that was directed to the court when we all know that it was not, sent a message to the community that the behavior in court was condoned, and that folks should act upon those calls of karma and retribution to be directed at the attorneys and their children. Those were mistakes. But as attorneys that are laboring every day in that courtroom, we have to elevate our work, but it's more important that the court control the atmosphere, control the rhetoric, and tamp down that process of allowing a courtroom that is there to only act as a symbol of justice to be used to call for violence.
Do you blame the judge for that? Judge Shearer in this case?
The blame should be directed towards the atmosphere that was created.
And who created that atmosphere, in your estimation?
The reality is that there was a lot of emotion in that courtroom. There was a lot of emotion that was anticipated and expected. And when you know you're going into a situation with all of that emotion, it is incumbent upon the court to control that atmosphere, to set a tone of respect, set a tone of careful deliberation, so it won't devolve into what we all observed. And that was unfortunate because that stripped many of the victims from an opportunity for closure, the distraction. And that was a growing atmosphere that was being created. It was unfortunate, and it should never occur. And that is why we have to address the behavior so it doesn't reoccur.
So tell us what you're doing to address the behavior.
You know, every client that we represent should recognize that a court's behavior towards the office or any particular attorney in the office should not impact their case. And as a result, every client that we represent before that court, we're going to have a conversation with, and we've had a conversation with quite a few of them, and discuss the possibility of a motion to disqualify the court. And a number of clients have agreed with that position based on what they observed and how the court has behaved. And they have expressed that they do not believe that they will get a fair shake in front of that court based on the behaviors in the past. That is our legal obligation to ensure that our clients are being treated fairly. And
so there is a complaint?
There has been a motion to disqualify over 130, and we will review every case within that division to determine whether it will be filed in future cases. But there has been a number of organizations that have voiced their displeasure with the court's behavior. There was a very, very powerful editorial in the Sun Sentinel that called for a review of the court's behavior to determine whether it aligned itself with the judicial canons of ethics. And there's been an outpouring of support from the legal community about the behavior, because that behavior in that courtroom emanates a chilling effect to all future jurors that may be compelled to come in to sit and hear difficult cases, and also sends a chilling effect to attorneys that are laboring and advocating on behalf of their clients, that if a verdict is not rendered that is sought, that they will not be the source of retribution. The work of an attorney is difficult, but it should not ever lead to outcries of threats of harm. We're advocates in the courts, and all parties need to be protected.
Do you believe justice was served?
You know, I believe that the jury listened to all of the evidence. They deliberated and they considered it, and their verdict has to be respected. That is the Constitution that we all have to uphold. And if we allow that to be diminished, then we allow a little bit of this democracy that we all treasure to be diminished. And I am not of that sort.
Do you have a message to the family members, the victims of what happened on February 14th?
You know, I acknowledge that there were mistakes made. I am here now and forevermore available for any family member that would like to have a conversation. I will extend myself forevermore. I recognize and appreciate their pain. But the jury spoke. The process worked. And we have to respect that process. That is our court system. We cannot diminish it. We cannot try to suggest that it should not be followed or it should not be believed. We cannot devolve ourselves into a society that tries to suggest that jury verdicts are compromised or not valid. We have to have more respect for the system. We have to have more respect for the process and the laws that we all uphold.
Gordon Weeks, thank you so much for joining us.
Thank you.